Hi, everyone, and welcome to the Looking Forward webinar with Legalese with the Ladies. My name is Sean Whalen, and I am a co-founder and the CEO of HopSkip. For those of you who are not familiar with HopSkip, HopSkip is a platform for professional planners and hoteliers to use to source and manage the process of booking a group or meeting at a hotel. And since we know that COVID-19 has had some major impacts to our industry, we've been working with Barbara and Lisa over the past year or so to understand how those impacts not only impact our product, but also how they impact the industry at large. And we as HopSkip want to share some of those learnings across the industry. As far as our agenda for today, we're going to spend the first portion of the webinar listening to the issues that Barbara and Lisa are currently seeing when it comes to the legal side of events, as well as any issues that they are seeing moving forward. We'll then roll right into discussing the questions received in advance of the webinar from today's attendees. And that said, we do highly encourage anyone to submit questions during the webinar using the Q&A button, because those questions will help form future webinar topics. All right. Before we begin and we jump into today's presentation, the main reason really why we've received such positive feedback on our webinar series is because of you and your input. It really does help shape the content that we present, and we can't thank you enough for everyone who has submitted questions in advance. Before we jump into the webinar itself, I am going to release a poll question here on the topic of feedback. Let me see if I can get this rolling. All right. If you guys don't mind providing a response back to this poll on the screen now, and we'll jump right in. I'm going to give it a few more minutes, or excuse me, seconds, and we'll get rolling. All right, wow. Great input. Thank you all. Okay. I'm going to pass it over to Barbara and Lisa to provide a quick intro, and we'll jump right in.
Thanks, Sean. Good day, everyone. It's nice to be with you. I'm Barbara Dunn with Barnes & Thornburg, based in our Chicago office. Pleased to get to work with groups in connection with negotiating their meeting and hotel contracts. And I'm happy to be here today with our good friends from HopSkip and along with the other half to our dynamic duo, Lisa Summer-Devlin.
Hi, I'm Lisa Summer-Devlin. I'm based in Phoenix, Arizona. I'm an attorney that has been representing hotels and resorts for about 30 years regarding convention and group related matters. I've been working with Barbara on presentations like this for many years, and we really enjoy the opportunity to work together and give you two sides of the perspective in dealing with event contracts. And we're really having fun working with HopSkip. They've been a great group for us.
We're having fun working with you guys too.
Go ahead, Barbara, you give them the disclaimer.
Yeah, okay, I'll deliver the disclaimer today. So although we're both lawyers, and I know we have a lot of our clients online, and we thank you for that, we're not going to be offering specific legal advice. We'll definitely talk about general concepts. We'll try to stay away from the two-word answer you hate, which is it depends, but that might come up. So just give that disclaimer. We know every situation is different and it does depend on the circumstance. So we'll try to flag that for you so you can kind of understand how it might equate to your question as well. But certainly if you have any of your own questions, talk to your legal eagles.
Okay,
so
Barbara,
with that said, just Lisa and I want to share just an intro to kick us off in terms of what we're seeing. And again, we'd love to have your questions and comments in the chat to help formulate our topics going forward. So focusing both on the current situation as well as the path forward. And you, like me, may find yourselves in a bit of a Groundhog Day that's lasted almost a year now coming up. And of course, importantly, hopefully you and your families are staying safe and well. While the landscape is changing, a lot has remained the same in the last year. And from the group's perspective, that has definitely been something that a lot of you have said to me, gosh, I don't want to be talking to you again. And I said, I understand that. It's like talking to your doctor or your car mechanic, right? But it is something that everyone has been proactive in terms of planning, in terms of where we are in the COVID pandemic, and obviously in the vaccine rollout, how things are going. So I continue to work with clients on cancellation of contracts for meetings and events, hotel contracts, convention center contracts, and then all related vendor contracts as well. Again, not by choice. I always make the point, especially if I'm talking to hotels, and Lisa's heard me say this, that the one organization that would want to have this meeting more than anybody else is the group. And especially since many of you, like my clients, are coming into the 2-time club, where you've had to cancel an annual twice. So it's devastating financially. Of course, it's been devastating financially from the hotel side in our industry as well. And I know Lisa will focus on that too. We're getting some new phrases out there. Unfortunately, we're inheriting some of our current hated phrases from 2020, as in pivot, or my personal favorite, you're on mute, which I'll try not to do today. But lift and shift has become a popular topic, a phrase that I've used. And it's a way of describing the fact that even if we're canceling a conference this year in 2021, that we're willing to host that same conference at the hotel in another year. So essentially swapping out years. And we'll talk in more particularity about what to do in terms of amending the contract. But that lift and shift technique, both for the hotels and the groups, has been a really good way to resolve a lot of potential legal issues going forward. And it's, the fact of the matter is, I always speak to the hotel, the group picked the hotel, they want to be there. They can't be there this year. And so certainly talking about flexibility on the open years is important. Amending contracts, lots of amendments to contracts. So whether that's to change the dates, or whether that's to change the contracts that you have potentially this fall, as to needing flexibility with room blocks, attrition fees, food and beverage minimums, function space, you name it. That's really the name of the game. Remember, it's an amendment, not an addendum. And we'll correct you if you send it our way. But at the end of the day, it's really important to be specific on what you're changing and what you're not changing, and make sure that the amendment really syncs up to the contract. Certainly, it goes without saying that for groups that choose to have meetings right now or in the fall of this year, there are concerns about safety. Given the new variants of the virus, there's lots of concerns about the contagiousness. And probably the number one question I'm asked is, can we get sued if someone comes to our conference and says they contracted the virus? And I always say, yes, you can get sued. Courthouse is open 24/7, 365 online. And my related add-on, many of you heard me say this, is that plaintiffs' lawyers need to send their kids to college too. So, all the things with causation aside, and all the fact that, as I know Lisa will remark as well, that there'll be new case law coming out of this for sure. Certainly it's important, if a meeting is to go forward, to think about liability. There are lots of ways to practically manage risks. Hotels have led the way with their standards, and convention centers as well, in terms of cleanliness, other safety issues. From the group's perspective, it's really important to set the rules of the road at the time folks register for conference, letting them know what the rules might be with regard to face coverings or distancing issues as well. We'll talk specifically today about vaccines. I know that's a popular question for folks, not only in terms of, as we're all anxious if we haven't already to receive the vaccine, but also just in terms of whether a group could require a vaccine for their meetings. And that might be something, again, on the path going forward. Let's talk about that path going forward. And I'll use another F word here. This is a good word, flexibility. Flexibility is really key on the path forward, both in terms of the hotels and the groups. From the group's perspective, we don't know what our meetings are going to look like. A lot of the groups, a lot of my clients that were resistant to virtual events, but were forced to have an event last year, have turned out that they really like it. And in many cases, they got more folks to the table than what they would normally do for an in-person meeting. So that said, a lot of the groups are anticipating some virtual component going forward. So flexibility, again, in adjusting a room block, function space, food and beverage minimums, attrition fees, those are really going to be important on the path forward. from the hotel's perspective, and I know Lisa will share this as well, but deposits have become more important. Even if you're a group with well-established credit with a hotel, understanding that the nature of the economy and the downturn right now is that it's impacting every business. Credit is back under issue and under scrutiny. And in some instances, that means paying deposits. Maybe you've never paid a deposit, or making more deposits. And so that's something on the path forward to look out for as well. Certainly, as we advent from this, you'll see a lot of buyer's market terms again. I know a lot of the clients have talked about hotels offering no attrition fee, which again, we can talk more about. Make sure you say no attrition fee. That's important, not to just leave it to silence, but really making sure that you have the flexibility you need, again, on the economic terms, the business terms. One other thing I'm seeing, and that is with regard to concessions, because of the potential virtual components or hybrid events, a lot of hotels and convention centers have really done a great job upgrading their bandwidth and other technology to allow groups to broadcast from the hotel or to have a part virtual meeting. So when you're looking at your concessions list, look for that. Look for things that are going to save the group some potentially new costs or new savings that may actually take priority over things you might have needed in the past, like a crazy number of suites or whatever the case may be. That may be something to really focus on. And I think we're going to see that reallocation of resources as groups kind of determine what it is that they want to do on that path forward. And Lisa, I know you, like me, are riding that path forward with our tennis shoes on or flat shoes on and flip-flops, hopefully with warmer weather soon.
Thanks, Barbara. Yes, we are. Some of you have asked if there's slides regarding this portion of the presentation. There is really not. Barbara and I are just kind of freestyling here, talking about things that we're seeing and thinking about in the industry. We're going to get to more slides in a little bit when we're addressing specific questions or specific issues. In terms of what I'm seeing going forward, I'm an optimist by nature, but I'm really optimistic right now. In the past few weeks, I've been talking with my hotel clients. They're seeing a lot of transient demand picking up. They are all having small meetings of one kind or another, and things are moving forward. And of course, we've seen great news in the past couple of weeks. The surge that we had over the holidays appears to be abating. We're going to have a third vaccine that should be approved any day now. So we're looking forward to things opening up and starting to get back to normal. So what am I seeing in the industry? Well, with events that are scheduled for 2021, I'm seeing two types of letters. The first type of letter is the one I've seen 100 times since last year, where somebody's lawyer sends a letter to the hotel saying the World Health Organization declared a pandemic and therefore we can cancel our October event for 2021 without payment. The second kind of letter I'm seeing is, hey, we've got an October 2021 event. What's our status here? And as you can imagine, you're going to get a very different response to the second letter than you are from the first letter. There are no hard and fast rules at this point as to when events are going to go forward because it depends on every event. My recommendation is that for both sides of the coin, you should sit down and have a discussion and say, how big is this event? When is this event? What are the local restrictions? Who are the people coming? Where are they coming from? What can we do? I had a call yesterday with a client where we went through that and decided that for a very late spring meeting that under the current guidelines as we know them to be, that it just wasn't going to happen. So we agreed to move the event to the next year. But the interesting thing about that was the discussion started back in December and both sides agreed, let's wait until late February, address it again, and then make a decision based on what we know at that time. Very congenial, very easy to do. Also think about what the practicalities are or what's really happening with your event. I had an event scheduled for early summer that was scheduled in a resort location. The plans had been approved by the local government for distancing and all those kinds of things. The organization had decided to have all of the presentations virtual. So the people in attendance would be there, but they'd be watching in their rooms or they'd be watching on their devices by the pool. And then there would only be limited food and beverage. Suddenly the organization decided to cancel. And when we looked at the reservation page, we saw that the room block was pretty much full. And so people wanted to go, they were planning to go, and yet the organization decided to cancel. that's an opportunity for a conversation. And I think you should be talking about what's going to happen. I know there's a lot of pent up demand to go places. I know I can't wait to go anywhere. And I think a lot of people feel that way too. So I think when customers are worried about canceling events in 2021, they need to really talk to their potential attendees and see what they want to do or how they would be willing to go. You've got to remember that the law has never addressed this kind of situation before. So you're going to hear Barbara and I agree a lot on trying to come to resolutions of these things, because you don't want to be the test case. You don't want to be the lawsuit that ends up going through appeal and takes years to resolve, and neither side may get the result that they want. It's better now to deal with the current realities and try to reach a resolution that works for both sides. As to events, again, I just want to add one point. Remember that all those thousands of events that have canceled in the last year didn't have special COVID clauses, didn't have unique language, and they were all allowed to cancel without liability because it was obvious they couldn't go forward. So going forward, what I'm seeing as new business is indeed starting to be booked. I'm seeing that customers realize that it is indeed a buyer's market. As Barbara said, this has been a devastating impact to the industry, and they are anxious to get new business on the books. I've seen this many times in the past when there's a buyer's market after a recession or after 9/11 or whatever it was, and customers come in and try and, I don't want to say take advantage, but they try to get very favorable terms. You can do that, but remember, memories are long in this industry, and if you're trying to take advantage or get more than is reasonable, that will be remembered and the value of your business will be viewed differently. Barbara mentioned no attrition clauses. Y'all want us to disagree? Here's one where I disagree. Well, we agree more than we disagree on this, I think. I think no attrition clauses are a very bad idea for both sides, because I think they make your contract unenforceable. If you go to a judge and say, I have a 500 room night block, and if I only pick up one room, I owe nothing. But if I cancel the entire thing, I owe $100,000. A judge is going to say, that's crazy. You don't have a contract. Even if there's a contract term that says that the parties expressly agree that no attrition doesn't invalidate it, even if there's a deposit, I don't think that contract's ever going to be enforceable. So as Barbara and I would agree, instead of having no attrition clauses, as we're booking business going forward, we understand that you're concerned. We understand that you know or don't know what your pickup may be because everything is different. So negotiate clauses that allow you to release rooms at various intervals, negotiate attrition clauses that may be more favorable than they would have been in the past. But I don't think no attrition clauses are the way to go forward. You know, and as I always say, well, no, that's saying pigs get fat and hogs get slaughtered. That's really true. So, you know, Barbara and I have a colleague named Joan, who I know is listening today, who told me this week that, you know, gee, you guys don't disagree enough. And so why don't you disagree more? You're on different sides. I think the emphasis of our relationship with HopSkip is we want to make people have events that work for both sides. And so while Barbara and I are on different sides of the coin, our advice here, and it's not legal advice, remember, but our discussions here are to help you get to a solution that works for both sides. And so you're not going to hear a lot of disagreement because we're trying to help you figure out a path forward that's going to work for both sides. So Sean, with that, I'll turn it back over to you.
Excellent. And before we jump into the next slide, can somebody just confirm to me that you are seeing the new slide progress? Because I know we've been getting, we are. Okay, excellent. All righty, so before we jump into the Q&A, folks, we wanted to let you know that HopSkip is currently offering your first year free when purchasing a HopSkip Pro subscription before March 31st. We would love to show you the HopSkip platform, how it can save you time and simplify your sourcing process, as well as some of the new features that we've built with the partnership with Legalese with the Ladies. So if you'd like to book some time with us, I'm going to display a poll question on the screen now, and please answer yes, and we'd love to get some time scheduled to show you HopSkip. All right.
I'm not seeing the question, Sean.
Yep, I know.
There you go.
No, this is the wrong one. trying to, give me a sec here. Oops. All right, we will come back to that poll. Don't want to waste time on the Q&A. Let's jump into that now. All righty, first question. Can we require attendees to be vaccinated before the meeting? Are there any issues relating to requiring proof of vaccination? If so, should we not be storing that information?
Barbara, why don't you jump in, because I know your firm's been active in this arena.
Yeah, absolutely. Thanks, Lisa. The short answer is yes. The longer answer is you got to think it all the way through. So yes, a group could require vaccines to have folks attend the meetings. However, there are two notable exemptions which apply both in an employment context as well as in a public accommodations context. That would be if someone had a medical condition which prohibited them or from getting the vaccine, or a sincerely held religious belief that would prevent them from getting the vaccine. Absent those circumstances, those are really the main exceptions that a group could make. Now, from a practical standpoint, this year or until there's a large portion of the population that can get vaccinated, we're going to have a business issue in requiring vaccines in the short term. If you did require vaccines, you're just likely to have less folks that are able to qualify. So that is something to think about as well, just on the practical side of it as well. In terms of any kind of health information, if you collect it, you've got to protect it, meaning that you have to store that data somewhere. And although a group wouldn't be a healthcare provider per se, subject to the requirements of HIPAA, there are a number of other laws that would apply, including the Americans with Disabilities Act, as well as the Genetic Information Act. So it's really important to make sure you understand what's to be collected. Lots of discussion about a vaccine passport and the like in terms of proof, and I'm sure that will evolve as this comes true. But Lisa and I chatting the other day, Lisa made a great point, which is when you ask for someone's ID, if you're going to serve them liquor, you look at the ID, make sure they're 21 or up, and you serve the liquor. You don't take a copy of the license. Similarly, we may look at that for the vaccines in terms of checking it off a list, but not necessarily asking to retain a copy because of the information that's on there. But if you have that, if you have the information, again, you've got to protect it. So I think on the going forward, a vaccine policy is a reasonable outcome. Don't forget also that we're not just talking about our event, the attendees at the event. We're also talking about the hotels and the venues. I mean, there's a big push, obviously, to get our hospitality folks vaccinated, and that might lag behind what a group's vaccination policy is. So you really need to look at it overall. And we can talk more about other practical ways to manage risk at the conferences. But Lisa, I know from the hotel's perspective, I've talked about a little bit on what the vaccine requirements could look like on both sides, and certainly from the employment context.
Right, and from the employment side, that is an issue going forward, that they are going to be in a position to make a decision about whether or not they can require it. And Barbara's point too, maybe you just want to see proof of vaccine and not keep records about that might be important. The other issue that's out here that's very amorphous and that is going to be difficult for everybody to deal with is, aside from those religious beliefs or health beliefs, there's a substantial portion of our population that for whatever reason doesn't want to take the vaccine. And your organization, if you're making a decision that you're going to require vaccines, is going to have to decide how you're going to handle that portion of your attendance. And I don't have an answer for you. I think it's going to be a tough call. You may decide from a health standpoint that you're going to require it. I wouldn't disagree with you, but in doing that, you need to consider the fact that they may negatively impact your attendance.
Awesome. Appreciate that one, Lisa and Barbara. Let's jump to the next question here. All right, any value in requiring attendees to sign a waiver?
Now, let me jump in on that one first. There's a potential value, but the thing that you need to understand is that waivers are extremely difficult to enforce. The law on pre-injury waivers varies from state to state, which also makes it more complicated if you're having attendees coming from all over. But in general, with something of this nature, something that is an illness that someone could get as a result of being at your event, it's probably going to be very, very unlikely that you're going to be able to enforce that waiver. Now, does that mean you shouldn't do it? Not necessarily, because sometimes just the fact that somebody has signed a waiver is enough to deter a claim. As Barbara said, anybody can sue you anytime for any reason, good or bad. And sometimes if they have agreed in advance that they aren't going to make a claim, it's enough to deter them. The other thing you want to think about, though, is the optics. Do you really want to have people coming either into your hotel or into your event to have to sign a document that says, hey, if you're coming here, you might get this disease and drop dead? And so you might not want to approach it that way. I think the more positive thing of requiring safety, things like masks and distancing and vaccines, might be a better way to approach it. Barbara, what do you think?
No, I agree with you, Lisa. A release and waiver certainly is not a complete shield toward liability. Certainly for the reasons Lisa mentioned. I also agree with regard to the optics. One thing I've seen a lot of planners do is to put in their registration materials release and waiver type language, essentially using what I'll call a default agreement or a default consent, meaning by registering for the meeting, you agree to waive all claims, etc. This isn't one of those things. This isn't like a photograph release where you say by coming to the conference, you agree to be photographed. This is someone giving up their personal rights. So that's going to have much higher scrutiny. That's going to need to be a separate document, a separate consent if the group is going to do it. So my feeling is you either do it all the way or you don't do it. And that's really the key. When we look at other ways to manage the risk, as Lisa mentioned, there are lots of practical measures to make sure a problem doesn't happen. So all the various efforts that the venues and hotels are doing, what the groups are doing relative to if you're coming to the meeting, here are the rules of the road, and making sure that that's clear at the time someone registers for the conference. Now, ideally that might change, but it may be something that you think about again and put into the registration materials as well. Insurance. A lot of general liability insurance, some of you call it special event liability insurance that covers the proverbial slip and falls at your events, likely wouldn't cover a claim against communicable disease. You got to check the policy to take a look at it. So groups are managing the risks along with the hotels and the venues, both on the practical side with practical measures and then potentially with release and waiver documents. But again, be careful on how you approach those, because I really do think that, the benefits of having a potential release being enforceable likely is outweighed by the detriments of either not having them be enforceable or having the optics really work against a group. And I think this is going to be a particularly sensitive issue in the upcoming path forward, that is through this calendar year. I think there's going to be a lot more sensitivity around that. And just going back to the vaccine piece for a moment, I personally think the best strategy is to encourage vaccines, but not require them. And that's something, again, and that's just a short-term comment, but it is something to think about, again, in the waves of being sensitive to all and understanding, really, again, as well, and not only folks who don't want to take it, but the inequities out there, which might prevent folks from getting the vaccine by a certain point in time.
Awesome. All right, next question. Do we need to provide temperature checks to our attendees?
Well, that's another arena that it could be fraught with peril. First of all, a temperature check is a moment in time. The fact that a person doesn't have a fever right now doesn't mean that they aren't already infected and that they couldn't infect somebody going forward. So it's not necessarily proof of anything. It's also doing what is called under the law, assuming a duty. You are taking on responsibility for doing something that you wouldn't otherwise have responsibility for doing. Once you assume that duty and take on the responsibility, if you don't do it right, you can be held responsible for that. So if you think that some kind of health check is going to be appropriate or necessary during your meeting, I would consider hiring a third-party agency that specializes in this arena to administer those health questionnaires or do the temperature checks or do whatever that is, so that they bear the responsibility for doing it right and making sure that it's done appropriately. so that you're not opening yourself up to that potential liability. And again, as Barbara and I said, we think things like mask requirements and distancing probably are better than doing temperature checks. I saw that somebody asked, well, should you require masks even if the local jurisdiction doesn't require it? Again, this is a very political issue, very fraught with all kinds of issues. But at this point, the CDC is still recommending on a national basis that everybody wear masks, and in fact is recommending double masking in most places. So I would go with the national standards for my event because people are coming from all over. But Barbara, what do you think in terms of temperatures and those things?
Yeah, so definitely I agree with you, Lisa, that the group can have more stringent restrictions than what the local area requires. And I think setting up a code of conduct, as one of the questions noted, is a good idea. Again, there's shared responsibility, and the Events Industry Council last summer did a great job in their report of really identifying the shared responsibility between the organizer, the attendee, and the venue when it comes to COVID risks. And I think that's true. I absolutely agree as to the third-party provider. Again, to give the impression that a group or its staff would check temperatures and somehow make a diagnosis is difficult. Similarly, with health questionnaires, remember, if you collect that information, you got to protect it. So that's not necessarily foolproof as well. So I think deferring sort of to the lowest common denominator, if you will, that is just practical management of risk on site. To me, I think that is the best strategy going forward. Also keep in mind, program schedules are likely going to change. It would take a hotel or a venue a lot more time, I should say, probably, maybe up to a half hour to turn a room in terms of doing the cleanliness, wipe downs and whatnot. And so groups need to think about how their schedules will change as well. You don't want to rush things like that. You obviously want to look at different strategies. And, I know that impacts food and beverage service in particular, and we can certainly talk more about that question. But again, as I'll point out on the group side, the same old just can't be the same old.
Excellent. Thank you, Barbara and Lisa. Before we jump into the next question, guys, we had some technical difficulties administering the last poll. So we're going to show that now, and I'm going to reiterate the message behind it. So HopSkip is currently offering your first year free when purchasing a HopSkip Pro subscription. So we would love the opportunity to be able to show you the platform and show you some of the new features that we worked with Barbara and Lisa to implement on the platform. So if you'd like to book some time with us, please click yes to the answer on your screen, and we will be happy to get some time on the calendar. All right, good to keep it moving. Let's jump into the next question. Should our own corporate staff be taking people's temperatures? Should we outsource that type of thing? And at what point are we making a promise that we can't really keep by trying to manage the situation on the ground?
Yeah, my answer to that question, Sean, is no. If you're going to have rules of the road of all the things that we've mentioned thus far, you don't want staff or volunteers or your board members enforcing those rules. You've got to think about that, and you've got to budget for that. I think one effective strategy is to consider having security folks professionally dressed, be able to approach someone in a respectful manner and remind them to pull up their mask or remind them to step back, to socially distant and the rest. And then if the reminders become multiple, then it's a discussion with the group. But you don't want to put your staff in that particular circumstance. So I would definitely think about, if you're going to have the code of conduct, again, rules of the road, make sure you know how you're going to enforce it, and make sure you take care of that cost. One comment and question that's come up a lot, I think, in the chat is, what about employees of the organizer? So, the issue is, if an employee were to contract the virus, whether that be at their workplace or at a meeting off-site, that is a workers' comp issue between the employee and the employer. But you're going to have the same concerns of unwillingness potentially by employees to get the vaccine. And generally speaking, and my guidance has been all along, and those of our labor and employment folks, is don't force an employee to come into the office or to show up at the meeting if you don't need to. I think that's the respectful flexibility that we're going to need to have for a little while. So I think that point is clear, but really be careful, I think, on site. And, you know, the point has been made, manage it. You got to manage it on the ground. If you're going to have a rule, you've got to follow it. And folks are looking. Look, we all have a video camera and a photograph right in our hand. And maybe even more convenient than that. So, you know, folks are going to pay attention if we're not enforcing mask requirements. And not that that is the major issue. Of course, the major issue is you don't want to become a super spreader event. But it obviously also impacts. And I've had a number of nonprofits where their areas in the healthcare arena, certainly, or safety, that have raised issues. Like, we have to be the model, right? You know, we have to show how this is done. We don't want to have this headline use it against us. So Lisa, I know you and I have talked a lot about this issue as well, and enforcement. And I'm sure as well on the hotel side, it's frustrating if a group, you know, isn't enforcing rules, and maybe that's disrespectful or harmful potentially to a hotel staff.
And you're right. And we have seen, we've already seen things online where we've seen meetings where people are sitting there having a cocktail with their mask dangling, and, you know, people have been shamed for that kind of thing. I completely agree with Barbara. Whichever perspective it is, whether it's hotel or group side, it should be third parties that are enforcing these kinds of things, that are doing the temperature checks if you think that's appropriate, and enforcing the mask and distancing rules. You know, as you all know, it's sometimes easier to say, hey, it wasn't my decision, you know, the boss said I had to do it. Well, the same is true in this analysis. If you say, look, we have hired this third-party company that their job is to enforce safety rules, and we have to defer to what they say. So if they tell you you have to put your mask on, or they tell you you have to step aside, that's a lot easier than having a volunteer or a colleague that your attendee may know say, hey, pull your mask up. And so I think that that's a good way to do it. I know that my hotel clients are very challenged in this arena, especially in the area of weddings, because weddings are some of the first things that are really coming back because people have been frustrated. And so they're having a wedding and they have all these rules about social distancing and no dancing or wearing masks. And pretty soon everybody in the event has had a couple drinks and they're ignoring everything. And it's a really tough situation to be in for you as the hotel to have to try and enforce these rules. Or do you just put up signs saying, you know, dancing must be 6 feet apart so that you can show that you tried to tell people and that you couldn't control them? And again, remember, underlying this whole thing is all the politics that people feel, and I'm using politics in a broad sense, the politics that people are feeling about this entire situation. And so you can get into arguments, problems, et cetera, that can be very difficult, which is why I think the third party approach is a very good way to handle it. So I agree with Barbara on that one.
Yeah, and Lisa, just to jump in on that, before I would be remiss in not mentioning this, you have to consider amending your crisis management plan to address a COVID outbreak, a potential COVID outbreak on site. How are you going to manage it? So if you haven't done that already, or if you don't have a crisis management plan, now is a great opportunity to do that. I know a lot of our industry folks and organizations have good resources out there, but run the drill. What would you do on site? That is really critically important, particularly if you're dealing in a circumstance like this where you have a highly contagious circumstance. Sean?
And you're never going to be able to prove where somebody got it. Yes, there are super spreader events, but when you have people coming from all over the country, you know, you're never going to be able to prove for sure how it did or didn't happen. But if you can prove that you had a crisis management plan, that you had these steps in place, that you did everything that you possibly could that was reasonable, then you're going to be protecting yourself. And that applies again to both the hotel side and the customer side. Okay, Sean.
Awesome. I'm glad you actually brought that piece up, Lisa, because I know that that's been a lingering question as well that we've received numerous times throughout. Can you actually prove that the person got COVID at your event? So thanks for tightening that one up. All right, our next question is, we've been hearing a lot that the trend in events should be hybrid/virtual first. So we're wondering how to manage venue/hotel commitments. If we have signed venue/hotel contracts with a significant space, but don't end up needing all the space if we decide to do the hybrid first route with a smaller in-person event. should the venue work with us releasing / not charging the full rental amount?
Well, I think this is kind of going to me as the hotel attorney, so I'll jump in first. The first thing you have to think about is you have a contract, you have a commitment. And so when you say, should the hotel, they aren't required to amend that contract. They aren't required to do anything. Will they? I would think so. You know, at this point, hotels need business and they are anxious to have any kind of business that they can. So they want to work with you to create whatever event can happen. And as I keep telling people, some business is better than no business. Now, there are realities involved in that. You know, for a hotel to open its doors if it's been closed for several months, they have to have enough cash flow in order to bring back those employees, to turn on the air conditioning and do all those things. And so there's a fiscal side of it that's very important. And your point is a very valid one. If suddenly we only need half the space, what's the hotel going to do with the rest of that space? Flip that over though and sit down and say with your hotel partner, here's what we're looking at. Here's what we are considering. How can we make this work? I know that I have some clients that are doing unique offerings where they're saying, if you can't have your huge event in Chicago, then maybe you book several smaller hotels, one in Omaha, one in St. Louis, one somewhere else, and have a smaller event in each one of those that are linked in a hybrid meeting. Then everybody's getting some business, a few people are getting together, and it's working. There's all kinds of ideas out there, but you have to have a conversation. And I think you're going to find that at least for 2021, hotels are going to be very willing to be flexible to the extent that they can from a fiscal side of the analysis. Barbara, what are you seeing?
Yeah, absolutely. I agree with you, Lisa. And having the conversation, as you mentioned, is important. So if you're looking at meetings throughout the fall, for example, have the conversation now. If your board, your leadership is still mulling the options, that's the time to have a conversation with the hotel and ask about flexibility. And I agree with Lisa, and thank you to our hotel friends listening in today who've been most flexible during this difficult time as well. And as any renegotiation is, come to the conversation hat in hand. What can you provide the hotel in return? Again, as Lisa mentioned, a number of creative strategies here of managing it. I will say the obvious, which is on the hybrid side, that often we're looking at twice the cost from the group side because you have your fixed cost of being on site and you have the cost of being virtual. So, you know, it's not to say it shouldn't be done, but I've certainly worked with groups and, you know, between the cost side of it and everything else, it may be something that the group is unwilling to do. I also think the term hybrid is a little misconstrued in some cases because often it's not a circumstance where we're completely replicating the whole event. Virtually, it may be portions of the event. So that's also something to think about as well. And one question that came in the queue, if you are to amend the contract, in amending it, you know, if you're getting to the first or second or third amendment to a contract, you should just do a clean contract. And so a lot of folks ask me, you know, about that. And again, I'd say you can do an amendment if we're changing certain terms, but if you're really significantly changing everything, my recommendation is to just do one clean contract and sign off on that. That's much better than having a patchwork quilt of amendments that you'd have to read later on.
And I have to jump in and say I could not agree more with that. Barbara and I have both had situations where we've got 3 or 4 different amendments open on our screens or on our desk, and you're trying to see where point A and point B and point C went through that chain. And at some point, you've gone so far afield from what the original event was, it's better to just start over and have a document that says this original contract is now gone, neither side has further responsibility, and here's where we're starting over. I think that makes a lot of sense, especially in this new environment.
Excellent. All right. Next question is something that's very near and dear to everyone's heart over the past year. I've heard mixed messages on going into detail on what constitutes a force majeure event. Some lawyers say to include the kitchen sink in the contract, so there is no argument should one of those come up. Others tell me to be vague because being too detailed could inadvertently cause a non-listed event to be denied. What are Barbara and Lisa's thoughts on this?
Well, I'll jump in here first and say, remember, there are 2 parts to any force majeure provision. The first part is the grocery list, In this case, the question's directed at listing a whole bunch of bad things that could happen. And while emphasis is placed a lot on the grocery list, to me, that doesn't often make a difference because I'm looking at the second requirement, which is what does one of those bad things have to do to a party's ability to perform the contract in order for the group or hotel in this case to be excused from performance. So a lot of time and angst is spent on that grocery list, epidemics, pandemics, travel restrictions in and out of certain cities. I'm not saying you shouldn't do that. If that's important to you, you could try it. But from my standpoint, a good grocery list has the bread and butter items on there and has a catch-all provision, such as including but not limited to, or any other cause beyond the party's control. It's what many of you heard me say, this is the Icelandic volcano catch-all phrase, right? I don't know how many of you had Icelandic volcanoes listed in there. And actually have a client that has zombie apocalypse, which, you know, could fall into that bucket list. But more importantly, it's tied again to that second requirement. So here again, commercially impracticable, inadvisable, if you will, health safety standpoint, impossible, illegal, X% of the people can't come, whatever the case may be. To me, that's where the negotiation should be. I wouldn't focus a lot of effort and angst on that grocery list because again, often in most circumstances, there's no question. And Lisa, you and I have talked a lot about this, that like, what is the force majeure event, right? As the Supreme Court has said about pornography, right? You know, so it's not always that part of it. It's that impact on performance. I find that from the group standpoint is often challenged.
And I don't really disagree with Barbara. While I am known as a very stringent editor of force majeure clauses, when I got the zombie apocalypse, I left it in because I thought that's great. You know, if there's really a zombie apocalypse, we're not having this event. So I'll give you that one. But in general, I don't think you need long force majeure clauses. As Barbara said, it's like what the Supreme Court said about pornography. It's difficult to define, but I know it when I see it. And that has been the case for the last year. There was nothing about anything like this in anybody's contracts, and thousands of events went away without anybody paying anybody anything. So the problem that I have with having a very lengthy clause is that, as Barbara said, people tend not to look at the two elements. They look at it and they say, oh, here's the word epidemic, therefore I get to get out. And they forget that there are epidemics all the time that don't prevent meetings from going forward. I mean, why would you put epidemic in your clause right now? We're in the middle of an epidemic. So if you put that in there, theoretically, your contract could be canceled immediately. So I'm seeing these clauses that go on and on and on. I've seen, you know, half-page, page-long clauses that have all these subjective things, all of these difficult to define things, and it's just going to lead to disputes. The same thing is true with the second element that is so important that Barbara said. Is it illegal? Is it impossible? Is it impracticable? That's the basic law of force majeure, but I'm seeing customers put in things like concern for personal safety. Well, whose concern? What level of concern? Is it legitimate? I'm never going to agree to that because it's subjective and undefined. So you need to think about that. And while people fail to look at both sides, a good example I had was after the Pulse nightclub shooting in Orlando. A hotel client had a customer call and say, well, see, there was a terrorist act in Orlando, therefore we are excused from our contract. Well, yes, it was a terrorist act, but it had no impact on the hotel or the ability of the event to go forward. And so by putting terrorist act in, they'd open the door for that kind of dispute. So my advice is keep it very narrow, stick to the law of it, and have these discussions we're talking about. If your event really can't go forward, a hotel is not going to expect you to pay. The only time they get into disputes is when you're trying to use that force majeure clause is to get out of a contract that is no longer convenient for you. And that's where the problems really come up. So in my perspective, keep it short and have those ongoing conversations about whether you really can or cannot have the event.
Excellent. Thank you, Barbara. Thank you, Lisa. We're getting a bunch of messages in the chat I guess we showed the book a demo with HopSkip poll question a little too quick. So we're getting asked to show that again. I'm going to ask if the HopSkip team can display the poll now. We'll send that out for 30 seconds or so, and then we're going to jump right into the next question. Okay. All right, let's keep it moving. So the next question we have here is, what does a timeline look like for when a group can invoke force majeure?
I think the answer is the one Barbara, promised that we wouldn't give you, and that is it depends on all those factors I've talked about. When is the event? How big is it? Where is it? Who's coming? There's not a bright line. You can't say 30 days, 60 days, 100 days. Some clauses are putting in a date as a go, no go decision point, and that's one thing. But in terms of when do you know that it's a force majeure, I think that's a slippery slope. Barbara, what do you think?
I agree. And I think we don't recognize force majeure until X days out is a business decision. It's not necessarily in the clause. So the clause will govern the right as to whether a party is excused from performance. So that's the it depends answer, of course. I do think, though, one trend, and Lisa, you and I worked on this in terms of negotiating contracts, is that there would be some guardrails on how a group or a hotel could invoke the clause. In other words, if a particular restriction, let's say, is in place up to X days prior to the event. So there's a little measurable effect. We're all juggling a bit of a patchwork quilt of state and local restrictions. And while a lot of times, it may be the venue, is it located in a state or a city that might be more liberal in reopening, folks coming from other states may not have that case. So travel restrictions certainly, admittedly, is something groups are concerned about. And sometimes one negotiation strategy is to talk about putting a time frame around that. And it goes to the point Lisa just made, which is the go, no go date. And I think that's a really good strategy. And I think, a lot of times the reason you hear Lisa and I agree a lot is because we're often working together on negotiations to get to the end result. Not being we can be the junkyard pit bull dog if you need us to be, but at the end of the day, we know it doesn't benefit our clients in order to do that. And I think in this case, consider a time frame on the force majeure provisions. I think that's a reasonable workaround. I'm not crazy about COVID specific clauses. Many of those that I've seen ask the group and the hotel, quite frankly, to jump through 20 different hoops in order to exercise the clause. Again, I stick to the basics, the bread and butter. And, if someone says, you can't exercise it until X dates, look at your clause. Does it say that? Does it not say that? And deal with that accordingly. Lisa?
Yeah, I should just say, for those of you who don't realize this, yes, Barbara and I are really good friends, and we work with HopSkip and do all this kind of stuff. But we also have spent the last year on the opposite side of, I can't tell you how many of these cases. And so we've negotiated these outcomes. We've negotiated these clauses. So these are real practical things that we are doing every day. So yeah, I like the go, no go date. And that date is going to depend on the nature of your event and all the moving parts that are involved in it. But that's an objective standard that the parties can agree on. When I'm getting getting letters today saying we're canceling for December of 2021, I'm saying, how can you say that? Who could possibly say that? So that's why I like dates or numbers of days or something like that, because that's something both parties can agree upon. Okay, we're going to make a decision there based on the facts on the ground at that point. And I think that's a reasonable way to do it.
Excellent. Next question. It is getting more and more challenging to communicate with hotels that it is not safe to hold our in-person conference now that the vaccination has commenced. Any insights on handling these discussions and negotiations in the early vaccination era?
Well, since I'm the hotel lawyer, I guess I should take this first. Again, all the things we've said today over and over again, communicate with your hotel partners, tell them who your attendees are, what their status is, what your expectations are, and just have an ongoing communication. Don't draw hard and fast lines. Talk about when you can reach agreement based on, and I have seen this in contracts or in amendments or discussions that have gone on. If by X date, at least X percentage of our people are not vaccinated, then we can agree that we can terminate. That's an objective standard that a hotel might consider. Barbara?
Yeah, I agree with that, Lisa. I think the communication piece is key for the groups. Keep in mind that, and I'm going to say this, and you correct me if I'm wrong, and a lot of people are going to hate this, but the hotel doesn't really care what your group's problems are. They don't care if
That's
you
not
have
true.
your educational institution has bans or corporate travel or there's not money in the budget. I'm not saying those aren't important. And many of you I talked to on the group side, these are absolutely important. But if you're going to go to the hotel and make an argument, you're going to have to ground it in the contract language, and you're going to have to ground it in the facts and circumstances on the ground, and also, the business relationship side of it too. So I think it's important to really focus on that. I'm not saying don't raise those arguments, but hotels, venues, convention centers don't care. I mean, we have to look at it objectively and talk about it. And if your group has concerns about coming back to meetings this year, then communicate that. Look, Lisa mentioned earlier the fact that we negotiate a lot of these resolutions here. It's because the groups and the hotels, they want to work together again. So I think the natural ask, if you were to come with the discussion of we're not sure about October, is do you want to just go ahead and punt maybe and do a lift and shift to the next open year? And, Lisa, you and I've done a lot of these where, used to be in years gone by pre-COVID that, rebooks would have to happen within a short period of time. And now we've got a rebook, I think you and I talked about for 2031. So, it doesn't always work out, but I think that's the conversation. So don't feel that you have to lay in or dig in on the merits right at the outset. At the time you have the conversation, think about where your group is going to be in the decision date, and then really have the honest conversation with the hotel. I think that's the best strategy, and it makes it most likely that you're going to return to the hotel, and for that matter, return to the city, which is really important these days.
Yeah, well, my hotel client hasn't agreed to that 2031 date yet.
Right. When I hear a client say their next open year is 23, I'm like, hallelujah. That's a gift. But this is a product, of course, coming out of 10 plus years or more of a seller's market. Many of you are booking meetings long out. And so we're dealing with, in some cases, trying to shuffle meetings around, which, by the way, raises another point that Lisa and I have talked about, which is if you have a contract in place that you want to swap out with a contract for the one you can't have this year, and you're trying to move around, be very sensitive to the fact that the place that the hotel that you want to change the date on is going to want to be careful that the first hotel has released you from liability, because they don't want to be viewed as interfering with that contract. So if you hear that come up, that concept of intentional interference or tortious interference with contract, that's simply what it means. And again, we realize those swaps happen, but that is something that a lot of you have asked questions about lately. So just wanted to bring it up. And Lisa, I'm sure on your side as well, hotels are asking about that.
Yeah, a good example is there's a well-known hotel in the country that has announced that it's closing its doors never to reopen again, and has business booked well into the future. And a lot of customers are going to hotels and saying, hey, we want to move our 2026 event. We know this hotel's not going to reopen. And the hotels are very concerned and hesitant, because until that hotel management says you are excused from your contract, they could make a claim against these hotels for taking over that business. So it's a tough issue, and there's no clear answers on it at this point.
Excellent. So we are just about out of time. We're not going to have time for the remaining few questions. That being said, that just gives us the opportunity to be able to have another one of these in the near future. So please, if any other questions do pop up, I'm glad to see that the Q&A was filled. If any questions pop up after the meeting, please reach out to HopSkip, and we'll make sure to work them into our next presentation with the Legalese with the Ladies. That being said, I want to give a special thank you to Barbara and Lisa again for another amazing webinar. Thank you so much to everyone who provided questions in advance, and also everyone who took the time to attend today. HopSkip will be distributing the webinar link to all registrants early next week. And as mentioned earlier, HopSkip is currently offering your first year free when purchasing a HopSkip Pro subscription before March 31st. We'd love the opportunity to show you HopSkip, hear any feedback you had on today's webinar, so feel free to contact us at info@myhopskip.com. Thank you all, and have a wonderful weekend. We'll see you next time.
Thanks, everybody.
Take care.